JTH said on stream that he was going to contact an actual copyright lawyer. Yeah, Khronos, I don't know whether we said this or not. He's not admitted to practice law.
Gotcha.
So this guy is not able to represent a person. You're in deep yogurt. Like, that's a big no-no. That's it. Like, you're done. That's cooked. So here, that's exactly what they did. Like, he put it out there on stream, and then he put it out there talking with my client. That was why they did it, was because of misappropriation of likeness. Therefore, it's not fair use. Dude, you just messed up.
So this last Monday, I had the opportunity to interview Mario Cerami, the lawyer who is defending the indie game developer, Mr. Ferrantino, against PirateSoftware's unlawful DMCA strike of his video game. I did this interview on my live streams. Check them out. Covered drama. It's super fun. And if you want access to the full interview uncut, it's going to be on my channel for members only. Membership is only 99 cents. So if you're interested, come join the channel and you'll get more exclusive content like that. And you'll get access to all my other VODs after we finish the live streams. If you're interested in the live streams, I do drinking and drama, where I take shots until either I finish the drama or I can't speak anymore. But shameless plug out of the way, back to why you're here. I have gone ahead and cut down for your lovely viewing experience the entire interview to include the essential meat and potatoes of this. And I truly think that this is really useful. I'll have timestamps down below to focus on the different parts of the video, and you can go ahead and click through and find the interesting parts for yourself. Absolute last thing before the interview starts up for you. I did just want you to recognize that, yes, this guy is defending Mr. Ferrantino. He is going to make, the best calls, and he is going to sound like Mr. Ferrantino is in the right. It's his job. But I also think that Mario does an excellent job at playing devil's advocate for the other side, and he makes note of that. I just want you to keep that in mind, to recognize the biases at play, but also, take it for what it's worth, because this guy has a lot more knowledge and a lot more experience with this kind of stuff compared to your average armchair Reddit lawyer. But with that out of the way, I really hope you enjoy this interview. And I had someone asking a question, just like, do you have any kind of accolades or experience that you'd like to share, just for people to get a baseline of some of your experience?
Sure. If I talk about it a bit, I'm going to make some people angry, but
Okay.
I'm a free speech lawyer, so I'll tell you some of my clients. I represented for the biggest headliner was a co-defendant in the Alex Jones case, and the only one who didn't have to pay anything. We litigated through to the eve of trial. I represented the talk radio distributor. So they took the sound, they uploaded it to the satellite, and they were in throughout the whole suit. I represent Genesis Communication Network. Okay. I have represented from really ordinary Joe stuff, kids who use naughty words on campus, all the way up through. Right now, we have a very large lawsuit against Yale University. It's a very serious case. And we're litigating gag orders in that, and I'm under a gag order still in that case. So, and lots of things in between. So small through big. Free speech is a vast area of law. It touches on so many things. Here we have copyright and fair use, but it touches on criminal law. It touches on land use. It touches on video games and movies, and you being able to be with your friends, and campaign contributions. Anything that involves a communication is going to involve free speech law, which is like most of our law.
Hell yeah. Okay, awesome. Also, fantastic beard.
Oh, thanks very much.
I could not dream of it. Yeah. Well, I guess with that being said, I want to kind of push over to, you had seen my video, and from my understanding, I really suck at explaining law in comparison to someone with a bit more experience.
You weren't informed. You didn't know. You didn't know better.
Right.
Ignorance is forgivable. Like, you just didn't know. And part of the reason I'm involved in this is I want people to know there was misstatements of the law on several points.
Yeah.
And I hope that people don't have a view of the free speech that's smaller than it actually is. We already have enough of a fight.
Yeah, nothing irritates me more than being frustrated looking at, people on Reddit or just like in the comments saying with such absolute assurance something that I can't prove to be wrong or right because I don't know jack shit. So I really appreciate you here to kind of level that, because it's just nice to actually know what's going on and have someone coming from that place. Let's start with just kind of introducing how you came into this, because I think that's going to give a little bit of context for people that don't completely know what's going on.
So today's Monday. 2 weeks ago was when the DMCA takedown was initially done, and it was the Tuesday after that I started to get involved. Late, I was working until about 10 p.m. I got home. I upload YouTube as I do to kind of calm down. One of my things that I do when I get home. And then there was a video with 11 likes, I remember. And there was this guy talking about how there's a DMCA on his video game. Okay, I'm interested. And it was Jason Thor Hall, JTH.
Yeah.
And okay. And then he said, if no lawyer helps me, I don't know what I'm going to do. I'm screwed. Nobody probably will see this. And I was like, all right, guys. I'll reach out. So I immediately reached out to him, got familiar with some of the documents and the statements that were made online, and was not happy and realized that something should be done, or there was going to be something wrong was going to happen. And I stepped in. We had a representation agreement. Within a few hours the next day, I educated myself a bit more that evening and the next day. So we're talking Wednesday now. DMCA on Monday. Tuesday, I find out what's going on with the client. We have a emergency representation agreement. And then on Wednesday, after having reviewed the materials, I send a demand letter. Well, I attempt to reach JTH's team, and then we send a demand letter saying, take it down. The next day, he does. Now we're dealing a little bit with the aftermath of things. There's been some statements that were also not true, but that's sort of in the short of how I got involved.
For people watching, not super positive. I've kind of covered just kind of like beginning, middle, end of, interactions where, Thor, aka PirateSoftware, has commented on it, things like that. And we're going to get into more of Khronos, people like that they've named. But I also want to bring attention, if I can, here. So let's start with, I'm going to pull up. So these are the correspondence between Mr. Ferrantino and them when he reached out with a ticket in regard to the DMCA strike that he had received. He tried going on to PirateSoftware's Discord and trying to explain that, hey, your voice wasn't even in the build of the game that people had the ability to play.
There's a little bit of context I need to add here.
Yeah, please.
So before this, JTH said on stream that he was going to contact, and I'm going to try to say this in the same tone that he did, an actual copyright lawyer, particular enunciation, as if to correct people who don't talk to actual attorneys. He said he was going to contact an actual copyright lawyer who runs under the handle of Khronos. And that's relevant here, and it's also relevant in my correspondence with them. And he said that not only was there a DMCA takedown, but he also said that there would be litigation, that he would bring a case against my client. So those are two pieces here that happened before what we're seeing in this conversation that are relevant to the conversation. Right.
And I think at this point, that was when around the time that he ended up uploading that video. And I remember just towards the beginning of it, he was talking about, it's completely out, like it wasn't even in there, just kind of being like, hey, that needs, I'm making sure that that's done. And I think he mentioned reaching out to them, but he sets up with like him reporting. So he had made a ticket and he put, I received a DMCA on Steam and my indie game was taken down. There's no content even related to PirateSoftware on my game that is uploaded to Steam. So Khronos, who is the attorney that PirateSoftware mentions when he talks about this,
he says lawyer.
Sorry.
This is a hair-splitting issue. So he said that he was going to contact a copyright lawyer. And in the U.S., that means attorney. Like they're the same thing in the U.S.
Right.
Lawyer and attorney mean the same thing in the U.S. It means someone who's admitted to practice law and can have a client. A lawyer in the traditional sense, and this isn't how it's understood now. Traditional sense, a lawyer is someone who went to school for law.
Okay.
But isn't necessarily admitted to practice. But that's not how it's understood in the U.S. these days. So when you say I'm a copyright lawyer, you're actually talking about he's actually talking about someone who would be his attorney or would be reasonably understood to be his attorney.
Okay. Thank you for that clarification. Because it's just interchangeable for me. Khronos chats with Mr. Ferrantino here. So I guess on the Reddit threads, and then we can file legal proceedings based on the use of the clips and voice. You're entirely able to. And so he talks about this, and I want to specify and use his exact words because I think you gave me some more info and I think you can expand on this a lot better. But he says you're entirely able to voice act the lines yourself, and we would no longer have an issue with utilizing someone else's voice rather than Thor's. Utilizing someone else's voice rather than Thor's would turn this from a copyright issue into a mere parody. You cannot call it a guest appearance, but sure, feel free to include the lines he spoke as an Easter egg, etc. Steam has kindly provided us with your personal information so that we can file the claim in the state of Florida. I also just didn't really like how they worded that one. It's strange.
Oh, it's like threatening. It's
yeah.
obviously threatening. And he mixes apples and oranges and screws up the law. Like it's like painful. It's like listening to a 5-year-old try to play piano.
Let's just dive into it. So what exactly, let's just like the meat and potatoes, using somebody's voice specifically in the way that he had, Mr. Ferrantino, he would use direct voice lines that he had cut and put them into the build of the game that he was showcasing. How does that kind of fall into the law and what Pirate was talking about?
Sure. So we're actually talking about two sets of rights. Okay. So you have right of publicity, which has nothing to do with copyright. And you have copyright, which has nothing to do with right of publicity, but they can involve the same material, but they're different sets of rights. The DMCA only deals with copyright. Copyright is when you take something, an idea, and you reduce it to a tangible medium. So as soon as you reduce your voice, a performance, an image, this video, as soon as you reduce it to a person reduces it to a tangible medium, then copyright's attached. So when JTH streamed the sounds, the images, copyright's attached at that moment when he streamed, because he, with his intention, reduced it to a tangible medium. Who owns the photo? Person who took the photo, unless he's working for hire. So that's how. So copyright, when he talks, those sounds, those videos, that's all belongs to him as intellectual property. That's a federal right. It comes under copyright. It's a federal right. Then you have misappropriation, likeness, right of publicity. If somebody uses your likeness, like they put you on the front of a box of Wheaties and sell it. Do we still have Wheaties these days?
If you look for them, yeah, I like them.
Yeah, okay. I put you on my advertisement. I put a picture of you on my webpage and say, make it like you're endorsing me. Then that is misappropriate. That can be misappropriation of likeness that infringes on the right of publicity. You own your likeness is the idea. Right. It's not copyright property. It's not intellectual property. It's a common law thing that goes back before there was this thing called copyright. It's an old principle that you own the right to your own likeness. One thing that's interesting is you don't even have to use the actual sound. This is again where he gets the law wrong. So there was a case, Liza Minnelli brought a case against, I think it was Toyota, but I don't remember which car manufacturer it was. They used a voice imitator of her. The person sounded fairly like her. So it gave the sense that they were using her likeness, her public character, in order to endorse or to sell their cars. Okay. So that's a classic case of bad misappropriation of likeness where they can get you in trouble. That's not a copyright case.
Right.
That's nothing to do with, that's where maybe they thought they had an angle, because it's not like they used something she sang, reduced it to a tangible medium. It's not a copyright. And they had someone who wasn't her imitate her. Right. But in the same way, like if I have somebody voice imitate Darth Vader and try to put on James Earl Jones.
Yeah.
And I'm using that in a commercial, I got a problem. So that's one kind of right. If they used some of a song she actually sang, that could be a copyright issue. Okay. So here you have, in this little blurb here, we have Khronos already start to mix up the law here, which makes me upset. So DMCA only has to do with copyright. And here he's already talking about mixing in misappropriation of likeness, as if people needed more reasons to be confused about this area of the law. No. So now one thing that can be confusing is fair use as a defense to both of them. Fair use applies. They are both. Any copyright cause of action and any misappropriation of likeness claim, they are both limited by the doctrine, the free speech doctrine, the First Amendment doctrine of fair use. It works out a little differently, slightly differently in each context, but for the most part, it's the same. When you do a DMCA takedown, the DMCA, just to give a little bit of history to people who may not know, some people may know half of this, when the internet was still young and dirt was still cooling and so on in the 90s, online service providers, AOL, remember? Online service providers people were going to put content that was covered by copyright on there. And because the online service providers were republishing it, they were liable in copyright for infringement. This was going to be normally you couldn't get something taken off the internet unless you went all the way through a long lawsuit. And the lawyers got paid a lot of money. And this was becoming a very common thing, these copyright issues. So there was a fast track procedure that was made in order to try to get lawyers out of it to some degree. And there could be a way for the online service provider to be covered and for the people to get their things done, perhaps negotiate it out faster. And that's the DMCA process. A copyright claimant, someone who says, "Hey, somebody's using my intellectual property on your online service improperly." Here, YouTube or Steam, right? Somebody's using my intellectual property on your platform. You need to remove that right now. Then if the other person says, actually, they have to put in a lot of information that includes a way to reach them if you want to sue them.
Right.
That's part of the DMCA takedown notice requires this information. If you want to countersue them for bringing in illegitimate DMCA takedown. And then the person who has had their material taken down, the respondent, he can put a counter notice and say, hey, actually, no, that's mine, or it's protected by fair use. Or they can go to bat on it and say, let's throw down. We'll take this. Let's go to court on this. So he gives that notice. The initial claimant has 14 days to do something legal, or the material has to go back up. And that's sort of a fast way to resolve it. And that gets if the online service provider does this, even though they might be profiting, they probably are profiting from the copyrighted material. They are under a safe harbor provision. There's problems with it, to be sure, but it's way better than what we had before. One of the restrictions, now initially people people started using it as a bit of a censorship, using it as a gag to try to get down information that offended them.
Very familiar with this. YouTube, it is, I mean, I think I named it in my video, but the golden rule of YouTube is you don't falsely DMCA because of criticism. And when it happens, it's like it's a North Star of a channel about to hit the drain.
Yeah, YouTube has gotten much better about taking their own look as to fair use. I give them credit for this. They've changed. I think it was within the last 5 years. We really saw this sudden sea change. But in 2015, there was a case that went through the courts in the Ninth Circuit Court of Appeals. So that's pretty much the entire West Coast of the United States. Lens versus Universal is the name of the case. In short, you have to do a good faith look for fair use. See if the material that before you do a DMCA takedown, you got to look and see in good faith if your material falls within fair use or the material you believe is being infringed on.
Right.
And if you don't do that, you can end up being liable under Section 512F. That can mean attorney's fees. It can mean a lot of money because lawyers aren't cheap. We know how to bill. That's something.
Firmly aware. Yeah.
So here we have, if we want to go back to Khronos, here we have look, he's saying that the reason we issued the DMCA takedown is because you misappropriated the likeness of someone. If you use something like that, like if you use a state tort or you use trademark or you use something other than copyright to justify your DMCA, you're in deep yogurt. Like that's a big no-no. That's it. Like you're done. That's cooked. So here, that's exactly what they did. Like he put it out there on stream and then he put it out there talking with my client. That was why they did it, was because of misappropriation of likeness. Therefore it's not fair use. Dude, you just messed up.
So to clarify for people, first thing, can you summarize a state tort specifically? Like what are you referring to?
Yeah. I'm sorry. Thank you.
Totally good.
So a tort comes from the same root as torture. Right? If I do something, you may have heard of the term negligence.
Mm-hmm.
You may have heard of the term assault outside of the criminal context. If I do something bad, that's not breaching a contract, but if I do something bad that hurts someone else, usually that's called a tort. When you sue someone, it's usually a tort. Now, copyright claim is not a tort, but it looks like one sometimes.
Sure.
Misappropriation of likeness, it explains how this legal claim works.
Mm-hmm.
It is a state tort. It is something when someone does something wrong to you, like defamation or like assault.
Right.
It is or negligence that causes you harm. It is what you have to prove and how damages are calculated and what are the things, how does it work in the fight between two individuals or two lawyers in a courtroom? Who has to prove what? So misappropriation of likeness is an example of a state tort.
Okay. And then because they set it up and they were defending their DMCA with something that has nothing to do with copyright, or is not copyright, they're in deep yogurt, they're cooked. Does that mean from a legal side of things, if they were to try to go to court against your client, if they went against your client, if they presented that, it would just kind of be tossed because it's already built upon something that doesn't match up? Or
the judge isn't going to automatically toss it.
Okay.
If they do that, then I, as representing my client, I'm going to move to dismiss under certain things. I'm going to say they failed to state a claim upon which relief was granted. They didn't. They don't. This doesn't exist. This isn't how this works. They haven't said a copyright claim. They said a state tort claim, but they're trying to bring it under the copyright statute, and that's not how it works. They haven't even alleged that there's an infringement on intellectual property. They have alleged something else. So they may also do both. Like if they could do it right, they could say, well, we're bringing a copyright claim for misusing my material that I posted on my channel, and we're bringing a misappropriation of likeness claim separately. And those could all both end up in state court. And they, you can do that. They could still do it right. But if they don't explain how their DMCA takedown was lawful, I think I said I'm going to eat their lunch. So it's not okay. I'm going to get attorney's fees. You're going to end up paying for me.
And so on top of that too, they would also need to have an attorney if they wanted to have an attorney representing them, one that would be licensed to practice in the United States, because Khronos isn't.
Yeah, Khronos, I don't know whether we said this or not. Did we talk about Khronos's legal?
Just that he's in the UK, and so that fair use is a bit different in the UK.
Yeah, and he's not admitted to practice law. So in the US, lawyer and attorney are synonymous. In the UK, they're not. They're different. And a lawyer is just someone who is my understanding, and I'm not a British lawyer or a British attorney. They have solicitors and barristers, and people who are admitted to practice law are different from people who just went to law school. Here, we might say someone has a JD. Someone went to law school.
Gotcha.
So this guy is not able to represent a person. Sometimes, even if you're from outside the US, you can get a local person, a local attorney, to be the actual attorney in the US. I do that when I go to other states too. I'm not admitted to practice in. If I was in this case, we might end up in, say, Washington, where Valve is. I have colleagues in the state of Washington who would serve as local counsel, and they would sign off on what I do. I would do all the heavy lifting, but then I would be the local counsel. This guy doesn't seem to have any angle to be representing people.
So number one, and I think that's one of the two big things. So number one, the DMCA that they have set up, the way that they are trying to, explain the DMCA usage was improper to start with. But number two, the actual use of the voice, and I think we had talked about this, I believe there was a secondary thing, and it was the use of it in parody. From my understanding, you're saying that when it comes to using the voice lines in this game the way that he had, that potentially wouldn't even lead to a DMCA?
I gave you a copy of the letter. If you want to even pull it up, you can, because I got some analysis there, I think starting on the third page.
Yes. So this was, and sorry for the people, which document was this?
This was the document I sent on Wednesday after. So Monday, take down. Tuesday, I get involved. Wednesday, I say, you got to take this down in 24 hours or you're going to have a problem. So Wednesday, this was the letter I sent to him. I tried to contact them too and say, because I thought Khronos was an actual attorney. And I can't just reach out to people willy-nilly if they have a lawyer. If they have a lawyer, and I reasonably believe they have a lawyer, and it seemed like on stream he said, I have an attorney, I have to contact the attorney.
That's good. You're doing your due diligence, which is...
You need to. There are other things that Khronos did in terms of how he was talking to my client at the time that were not proper for an attorney. But nonetheless, I want to talk about right here. Fair use. We can come back to that piece. So here, I kind of have a very quick fair use analysis, just really short, half a page here. And I break down, there's 4 factors that are principally that you look at. And here's a brief analysis of, they should have done something like this. They had an obligation to do something like this, even though there was no material. Let's say for the argument that they believed that there was material, let's imagine that was a reasonable belief. I don't know whether it was or wasn't right now, but let's imagine, given the most charitable view, that was a reasonable belief. Whatever they reasonably thought was in the game, they had an obligation to analyze at the very least. At the very least, they had an obligation to look at what they thought was in the game before issuing the DMCA takedown. Right. And the analysis would in my view, go something like this. So the most important factor is the purpose and character of the work. So this is often what we call, whether it's transformative use or not, you consider things like parody. Or, here, the material wasn't being reused for streaming content. If, let's say, my client just copied the stream, added nothing else to it.
The video, audio.
Yeah, right. The video, the audio, he just rebroadcast it. That's not transforming it in any way. So here, my client took a few seconds of audio and put it into a video game. That's very different. This isn't something like a stream streaming video. This is turning it into both a work that's critical of JTH and something that is it for entertainment also, but for a very different kind of entertainment, an interactive video game. So this is no doubt, no question, in my view, transformative use.
I just want to ask this because of my sake. So when I was,
Sure.
I kind of fell down that same line of reasoning, but the thing that, gave me more of a worry into like, if this actually makes sense is the fact that the voice itself, although, in the context of where the clip comes from, it's included with that visual media being, a stream clip. However, the audio that he does use in it, the audio itself is not changed. And so I thought maybe how law works, because that specific part of it is unchanged, that therefore it's not.
The media is not changed, but the use is.
Oh, okay.
You dig?
Yes.
You dig?
I dig.
Yeah. The media is unquestionably not changed, but the context, the way it's being employed, the purpose behind it is very different. But that's a good question to ask. It's a very good kind of question. You're thinking like a lawyer, because that's like, what's the other side going to say? That's an argument that they would certainly try to raise. If I'm on the other team, I'm certainly trying to bring that up. There's other points where things fall flat, absolutely, but that would be a good point to bring up for the other team. Okay, you didn't alter it in any way. Well, you don't alter it when have you seen a reaction video anytime lately? They don't usually alter those either, but they add commentary that transforms the work from what it originally was into a work that's reacting or adding different content to it. And not always are reaction videos fair use. They often are and can be, in the same way that a criticism of a piece of a book that uses excerpts is all the same kind of thing. So here we have like a fleeting use, but nonetheless, transformative use. We're not talking about the other factors. We're skipping ahead, but is the purpose? This is for a very different kind of use. Transformative. Second, how much of the work was used? So in the post online, there was 2 or 3 seconds. In fact, in the build, he had intended to use about 41 seconds. 41. They might imagine, at the best, most charitably for them, no more than 5 minutes. Certainly, we're not talking about hours and hours and hours of streamed content being put into the video game.
Yeah.
Right? No reasonable person would believe that. But let's imagine they believed 5 minutes, 10 minutes, even though it was less than a minute that was actually going to be used. But okay, still relatively small. It's a small piece of audio from a much longer stream or array of streams.
Percentage-wise, it's pathetically minuscule. Yeah.
So percentage is one of the considerations, but you also consider how material it is. So it's less applicable here, but let's say I gave away the identity of the murderer in a murder mystery. That would be even though it's a really small fact, even though it's less than 1% of the book, it's really material and undermines the book a lot.
Could they then argue, because of the substantial publicity surrounding the popularity of those specific voice clips, like is that a route they would take, that because it spurred a lot of attention and they got a lot of views, clicks on videos, because, like in the clips that PirateSoftware uploads, if those specific voice lines are attached to them, that is kind of similar in like revealing, a substantial piece, because it does end up turning into something that monetarily benefits.
So the substantiality is about the work itself.
Sure.
And if it's substantial as to the work itself, you're talking about the context and the effects of the use. That may go to damages, or it may go to the misappropriation.
Gotcha.
But what you're describing is not applicable to the issue of materiality in this factor. It might be applicable to other arguments in other parts of the law.
Okay. It's just voice in a long stream. It doesn't.
Yeah.
Right.
Yeah. And it's not like this doesn't give away the murder mystery.
Right.
And then is this place the marketplace for the original work? Are people going to stop watching JTH's stream and just watch the video game? No, that's not going to happen. But if it did, then that would be a factor against, right? So nobody's going to stop watching JTH's stream just because they can get the same content essentially through the video game. Like they might find it hilarious, the criticism, and may no longer respect JTH, or not, or they may actually take interest in him as a result of the thing and say, "Oh, let me go see what this guy's doing." But there's no displacement of JTH's copyrighted material as a result of this. So that's a third factor. So far, we got 3 factors that weigh in favor of fair use.
Yeah, I had no idea that's how that was dictated. The potential market value stuff, I had no idea that it was like bringing it into a different market, or that they're going to stop watching the original source, or, you know, stop consuming whatever it is for them to switch over to something else. I thought it was just if they make money off of it.
Now that's an issue more. It's a factor with the nature of the work as to misappropriation of likeness. So if you use it in a commercial, you know, I'm going to deviate now. Remember, two different kinds of claims, right? Copyright, misappropriation of likeness. One's a state tort, one's a federal copyright claim. But misappropriation of likeness, you do, you know, you had the Liza Minnelli case versus Toyota or whoever it was. Liza Minnelli versus car manufacturer. And there they used it just in a commercial. It was literally only commercial. It was literally only in a commercial, right? And they used her likeness in that context. And that was for the purpose of making money. And would it displace? It doesn't displace a ton of her work, but the transformative use, there's no transformative use there, right? They're using it in order, they're using it in order to make a beautiful song in order to enhance the value of their Toyota truck. So there was nothing like, they didn't like split it up or try to use it as a criticism of her or anything like that. If they do make money, that is a part of the factor into the analysis too. Does he make money? Yeah, he does make money on this. And that is a consideration. If you do it for just free, then that's part of this factor. It is one of the things you analyze in these factors. But in this case, my client did make money on it. Yeah, that's a consideration. But he's not displacing the original guy. So it's ameliorated that factor seriously.
And sorry, when we talk about making money, from my understanding, the game itself was only a demo on Steam. So is that in response to like the fact that he got attention, like views?
He eventually will be making money.
I see. Okay. Yeah.
Yeah. So it's advertising. There's a commercial aspect to it.
I see what you mean. Okay.
Yeah. So, but for the most part, this factor weighs strongly in favor of fair use. And then you have the fourth factor, which is about the nature of the original work. If you have a creative original work, fair use is more narrow than if you have a purely factual original work. So if you are using part of the news, or you're using something that is just a rendition of the facts, using a bit of a blurb online, somebody does a TikTok post, and you're just using it for the facts of what happened, then that's different from, say, using a painting or a creative work or a movie or film where there was a lot of conscious decisions that were put together in order to make a creative a work as a whole. And here there are elements that go both ways. So there are definitely elements where streaming is a creative platform. You're doing things on the fly. You're being funny. It's not just relating facts. This video definitely, though, was relating facts in part. Part of it was saying, this is what happened. This is how things went down. But there are also creative aspects to it. It's not the same as if you carefully put a movie together. You're not thinking about things ahead of time. This extemporaneousness of streaming cuts against the creative factor element here. But there are good arguments both ways. There are arguments both ways. And so I call this kind of a wash. Neither side's got a particularly dominant position on this factor. But you got three factors under my analysis that slant strongly in favor of fair use. You know, attorneys might disagree with me. Another attorney, a logical attorney, might reasonably disagree with me on this. But the issue is that this analysis didn't happen at all. And you had to do something like this before issuing your DMCA takedown. And it seems that all they did was say, he used my actual voice, therefore it's a copyright violation. That is what gets him really in trouble. Less so that he didn't see if the sound was actually in the demo or not. That's there. That's an aspect of an argument to be made. But the stronger argument is there was no attempt to even do this analysis at all. And that's a big no-no. And
when you say big no-no, what is the consequence for the inaction, for the lack of, due diligence?
Sure. So if it is protected by fair use, I can get compensatory damages for how much it hurt. So my work now, if it's fair use, that's my copyright. You have some of your copyright in there, sure, but I am fairly using it. So now that I have reduced it to a tangible medium, that's my copyright. That's my thing. If you hurt my ability to profit from my thing, if you hurt my ability to use my thing, then I can sue you for the compensatory damages and for attorney's fees under 512F of the DMCA, Section 512F.
Okay. So the potential blowback.
Yeah. Okay. I couldn't sell my game for 2 weeks because you waited a whole full 14 days. And you said things that were not true. But principally, I couldn't make money for 14 days. I couldn't turn my game on, which I wanted to do, and go live with it. So that would be compensatory. But the bigger thing is the fact that we're now going to litigate this in court. and he's going to have to pay for me at $500 an hour.
Mm.
That's, or whoever the teams are, because I got a strong claim coming in now. And the reason for that attorney's fees shifting provision is so that lawyers who are perhaps not as altruistic as I am are incentivized to get involved even when the compensatory damages are low. So that's part of the reason for it. So somebody else might, if he had a strong claim, somebody else might take it up just for the attorney's fees. That's why you got to be smart and careful about these things. That's why you should talk with an actual attorney before you issue one, or you really need to know what you're doing before you do this.
There's just a built-in incentive, because now I just get a full payment, don't have to worry about it, being guaranteed, because it is if you screw up bad enough.
And there's a strategic consideration here too. Like the damage was already in part done. He did it less than 1 day, but he probably, we withdrew it in less than 24 hours. It's not like there's going to be a lot of damages there. And a judge is going to look at you very disfavorably if you go after someone for an 8-hour infringement.
Right.
So whatever it was, 24. You're going to have problems unless you can really show damages. And I wouldn't do that for a number of reasons. He'd have to go get another lawyer to do that.
Sure. So as far as realistically any future legal proceedings, that's looking fairly low simply because it was withdrawn so quickly. And I guess I would just say that the biggest, I think, blowback that's going to come out of this is just the fact that it was so poorly mishandled and misrepresented, the facts of the situation. Number one being that, at least from your perspective as someone who does practice law, this did look like a realistically, something that you could battle in court and argue that, no, it was fair use, even as it stands how it is, because it was transformative enough with the game, the creativity in it, putting PirateSoftware into a cockroach with a wizard hat and, saying this, just kind of circling back then. Number one, they were saying that the claim itself was not, they were not defending the DMCA properly. They were not even using the correct argument to defend the DMCA. And then on top of that, they did not appear to do any due diligence to even verify and confirm, by what you did going over these 4 points, that it did even realistically fall under being DMCA-able. Or DMCA strikeable?
Because they didn't do their good faith look.
Good faith.
They don't have to have the same analysis. They have to take a good faith look into whether fair use applies before issuing. That's what Lens says. The case Lens says. So it's disincentivizes people to a large degree to just use the DMCA as a censorship tool. Because you do that, you might hit the wrong guy. Somebody's going to know a lawyer, and the lawyer's going to be like, "Oh, deep pockets. I'm going to come for you. I don't like bullies, Mr. Deep Pockets." Now, the issue's not quite over because my client might want to use the likeness in it, right? So we have to analyze. So here I say this is how the copyright claim would probably resolve if we took it down the football field. It would probably be fair use and no go. But how does it go for misappropriation of likeness? For the most part, the analysis is the same. There's a bit of a nuanced difference vis-a-vis commercial use. It is being used ostensibly for a video game that's going to be making money, but the commercial use also isn't just commercial use. It's not just like he's just trying to sell cars with the sound of the guy. He's using a likeness for a very different kind of use, very transformative use. And there's criticism here, there's parody here. Those are going to be really important factors in whether state tort is trumped by the First Amendment.
Yeah, and from my understanding, it's also like the entire game is not centered around this specific instance. It's actually a collection of multiple parodies of different content creators. So even then, it's still a small piece of the pie when it comes to the actual content of the game itself.
Yeah, I think he's got QXC and Asmund Silver.
Yeah. Couple others.
So let me explain. Some people are going to wonder, like, normally lawyers don't talk, and there's good reasons for that.
Mm-hmm.
Why is Mario talking? And I've been pretty active even in your YouTube comments.
Which I've really appreciated, by the way. Thank you.
Normally lawyers shouldn't talk. You should avoid it because you can end up becoming part of the case. So you have a duty to be able to represent your client. And if you start talking, you might end up not being able to represent your client. You might end up becoming swept into a lawsuit yourself. And then there's going to be questions about whether you have, if your duty of loyalty is at risk because you're also being sued separately.
It's in your own interest,
Yeah. So that's a big reason why lawyers shouldn't talk. But there's a case called Gentile versus Nevada State Bar. Dominic Gentile actually is a colleague of mine. And the prosecutors in that case, it was a criminal case. It was about a criminal case. Prosecutors in that case, they said things that undermined his client. If his client didn't say anything, it was going to undermine him in the court of public opinion and may have affected the jury pool. So Dominic said things, Attorney Gentile said things that got him in trouble with the Nevada State Bar because he was talking about the case. Mm-hmm. And the U.S. Supreme Court said he had an obligation to talk like that. It's a violation of Dominic's free speech and his client's free speech to punish him for those statements when he had an ethical obligation to actually talk. When you have one side with a lot of access to media, like the prosecutors, and there's an imbalance there, then lawyers may have an ethical obligation to talk. And the audience, there's unquestionably, JTH has a large audience for reasons.
Right.
Good. He's an award-winning dude, public figure. And he definitely has an outsized megaphone when he talks compared to my client, who's very small content creator. So there's, in this kind of case, not only did I think I had an ethical obligation to talk and educate people because the law is wrong, I felt that in this particular medium, the people who are at play here, the people's opinions who are at play, they don't listen to the news. They're not on the 6 o'clock. They don't listen to 6 o'clock news. This is where they're at. They're on social media. So that's why, in particular, I'm talking here, is because I'm talking to the relevant audience as to this case. And that's why I'm active in the comments, because I think that people will read them. More people will read them at some point, and it will affect their view of my client. And I think I need to. I think reasonable minds could disagree. Another attorney might not take the same take. This is how I thought I needed to handle things.
Completely. And no, I think that's, the great comparison you made with your colleague, like that. That just sounds exactly like what is going on now. Pirate, or, as you refer to him, Jason, he speaks with a lot of bravado and confidence when it comes to situations like this. And for a lot of people, and I think a lot of the drama that surrounded him, literally leading up to this happening, a lot of people, including myself, I used to thoroughly enjoy his content. I'm very, and I think a lot of people, just as charismatic people exist, very easily swept up into a confident, charismatic person soapboxing. So when it comes down to exactly what you were talking about, why the Supreme Court ruled against it, it just makes perfect sense that, for a lot of people, they're just going to take what he's saying as that is how it is, because he says it with such complete confidence and seeming to have so much knowledge of what's going on. And to hear it, from you it's very interesting. And truly, it ends up making more sense as it's following the law. But
imagine somebody is in a divorce case, they just start harassing their ex with DMCA takedowns because their likeness is in certain videos that are online. Mm-hmm. And they think that they got a good angle to do that because that's what JTH said. And he had an actual lawyer. He had an actual copyright lawyer. That's not that you should never rely on legal advice, including me here. We don't have a representation agreement, me, you, and the audience, right? People will make that mistake because it's in their head and they may have heard it from someone else in the circle of misinformation that can happen in the echo chambers here. And you can see it in some of your comments, in some of the comments in the other videos. People have this really strong conviction on something that is just wrong. So, and maybe it is because of the way he says it. And let me say, I like him too. There are things I think he does that are really good. I think he does a lot of really good work for younger people. And I even say this in my letter, some of the criticism about you, even with the Dire Mall thing, how silly it is. I don't think he merits all the criticism he got. Other reasonable minds may disagree on that. And I recognize that. But your video too also made me kind of question. You had a video about some of the past things, and I'm not going to get into that, but as a result of this process, some of my convictions have been a little undermined. I'm more skeptical on the whole. The whole bullyishness that Khronos approached the situation with, the head moderator, that really upset me. Then there were statements on, we sent the demand letter to take it down. He takes it down right away. Okay, that's good. But then he has this thing on X that seems to like we didn't even send the letter. He just ignores it. He had this post on X. And then I'm like you're ignorant and then you fix it. That's one thing. You're ignorant. You pretend to fix it and then you claim otherwise still. You continue to miseducate people. That makes me angry. Please don't do that. Please don't. I'm trying to fix people's misunderstanding here. I'm trying to educate people a bit about how things actually work.
Ricky, I got a question. I'm a bit dumb, but as I understand, it would have been reasonable to go after something like right of publicity or defamation rather than DMCA.
So you don't get to do an immediate takedown with those. In fact, it's unconstitutional for a court to give an injunction before a trial in a defamation case. People don't necessarily know that. Lawyers don't even know that. But so the DMCA is very attractive in that it gets you to do something right now. You got to take it down. The online service provider is super incentivized to immediately take the stuff down because that's the only way they can enjoy the safe harbor provision.
Right.
Otherwise, they risk being liable themselves for whatever is going on. So they wouldn't be able to immediately take it down with a defamation or misappropriation of likeness. But those are both torts that plausibly could have been used. I don't know how you get to lies. I don't know how you get to a statement of falsity with the video game. I don't think, sure. But misappropriation like this. So in Thor's defense, he does have a distinctive voice.
Right.
There's arguments about whether it's real or not. I don't care about that. Even if it is modified, it's distinctive.
That's how he's known. Right.
Yeah. Right. So he may have a bit more of a claim than like me. Right. Or even Zach or Asman, right?
Sure.
We'll definitely talk about this video. But Zach, he's, Jason Thor Hall has got a distinctive voice. So maybe he's got a bit more of a misappropriation of likeness type claim. I still think fair use applies for a number of reasons. So that would be how he could have pursued it. But that actually, you don't get to do the fast track. You don't get to do the DMCA with that. There's one more thing. One more thing. States also have these things called anti-slaps. So if you bring a garbage lawsuit and it infringes on people's rights of free speech or of the press, some states, not all states, have these statutes that give extra protections. In short, if you bring a bad lawsuit, tort lawsuit, like defamation, but also misappropriation of likeness, and you should have known better, then you might have to pay for the other side's lawyer. There's a good one of these in Washington, which is where Valve is. So that one might have applied, that anti-slap. In the case you were talking about before I came in stream, you were talking about the TerraSoft case with GOAT. And actually his case, that he was sued in Ohio, even though nothing had anything to do with Ohio, and there was no anti-slap in Ohio.
Sure.
He used his case in testimony to the Ohio legislature this year, and they passed an anti-slap. And I'm told my testimony about that case, which went on in Ohio, was persuasive, because I was like, people are going to start shopping in Ohio because there's no anti-slap here, and here's an example where it happened. So so anti-slaps can be, you might stumble into another problem if you jump the gun and you bring in a misappropriation of likeness or defamation claim that's garbage in order to try to silence someone using the law as a gag, depending on the jurisdictions involved. So that would be another reason why I would probably advise against it. For if I were on the other team, if I was on the other side of the VM, I would probably say no.
That's so kind and charitable of you. Yeah. Okay. Last one comes from Cute Little Kitty. Thank you very much. Could an argument be made that since Jason is releasing a game on Steam alongside another unrelated game featuring his likeness, voice clip of him, there might be some form of competition clause involved?
So my response, I wish I could talk with this person, because I would kind of give them a Socratic discussion. I would say, so tell me about how my client's video game displaces JTH's video game. Because if my client's game does displace JTH's video game, then maybe you have an argument. That might be it. I don't think there is. I don't think there is such an argument. But just for the sake of, to play devil's advocate, to explore the legal issues, if you could make that argument that there's a displacement of JTH's intellectual property from this otherwise fair use, that's one of the fair use factors, right? So to what degree is or displacement of the original IP or the original copyright rights, including his right to make a video game about himself, to what degree is there a displacement of that? I own, it's not Heartbound. Heartbound?
Yeah.
I own it. So, like, as much as it's made, right? So
I was just about to say something about it, but yeah.
I have purchased a license to play. To the extent that I don't think that there is. I think that would be a creative argument. I will say, one of my favorite things to hear a judge say to my opponent is, that's a really creative argument. That That means you had the second best argument that day. If the judge tells you that, if the judge says you have a very creative argument, you had the second best argument that day, and
That's so funny. Yeah.
So, so although it's creative, I just was, that's I like to be boring as much as I can. I try to make things boring as a lawyer because boring, in my view, is winning. So
okay, yeah, and I would say just to play that devil's advocate, I think they're number one, two different genres. They're different in that sense. On top of that, as long as your client, isn't developing the game over the span of nearly a decade, I think that would also kind of be a bit of a difference there. But
I'm going to imagine that Kitty, because she has a creative mind and came up with a creative question, shortly after I asked the question, it's going to come up in his or her mind, their mind immediately, like, oh yeah, okay, I can see how. All right, and maybe they have interesting thoughts. In which case, I would encourage them to explore it on ChatGPT or Claude. I actually these days I like Claude a little bit more. I think it's a little more eloquent.
I'm going to be putting this down into kind of a video. But is there anything that you'd just kind of like to cover?
Yeah. So not a lot of content creators talk about political issues like free speech. And one of the reasons I was really thankful that you gave me the invite, it's really important one of the egregious things was this miseducation of the public. If content creators have a question about free speech, it's not that hard to find me. There's only 3 people with my name in the United States. I'm the only lawyer one. So you can find me pretty easy. Reach out. I'm not going to charge you a cajillion dollars. I will probably do it pro bono if it's just like a conversation. Hey, Mario, is this how it works? If you're curious, if you just want to do it for educate, if you're serious about it and you're serious, give me a call. I'm sure we can figure it out. If you're just curious, 95% of the time, now there's a critical 5% where this doesn't work, but 95% of the time, Claude, ChatGPT, they give you the basics fine. Now they will make up cases, actually in pretty sophisticated ways. I will use these things as compliments when I'm writing, when I'm doing legal briefs. I will use them to challenge me to find holes. I will use them to, in chess, look for blunders. You might have the
yeah.
I will use them to help me look for blunders in my briefing. I will also use them to help me come up with ideas. Sometimes there was a time I can think of right now. I was trying to think of times when when free speech attached, but you didn't have to actually talk. And it suggested to me parades, and I hadn't thought of parades. And I was like, yeah, that's a really interesting way to use it. I'm going to use that. So free speech, when free speech rights arise without you actually having to invoke your free speech rights or actually engage in them, when can they attach like that? And it suggested parades because you're not talking in a parade. And I was like, yep, it's a really good angle. My point is that ChatGPT, and they're pretty good. If you just want to in a fun exercise, learn about it, ask them questions. They're pretty good.
I think it's interesting that you say that, because I feel like I think it ends up benefiting you a lot more in comparison, just because outright when it's twisting it or when it's incorrect. So it's just, I think that's kind of like anything where, even for me, for YouTube, if I have somebody, in my family, like my fiance, bouncing ideas off of me, I know the ones immediately are like, oh no, can't do that. Absolutely not. But then I hear, something that I've never thought of, and like, no, but I can utilize that in a way that I hadn't been prepped. Okay. Very cool.
It's worse when you come up with really crazy examples. If you're dealing with kind of the meat and potatoes of the
issue,
it's going to be fine. If you almost every time, but if you come up with weird hypotheticals, it's going to start in order to try to appease you. So there's things you can do with prompts in order to mitigate against that, but I know when it's making stuff up most of the time. I can kind of tell. There's a way it cites cases. I can tell it will make stuff up, just plain make stuff up, and on what it thinks that you want to hear about the law, which is really dangerous. That's in the corners. In the meat and potatoes, you're fine. Can you burn how does free speech work in the context of burning a flag?
Okay.
It'll be.
Thank you so much. Seriously, this was honestly I really appreciate that you even took the time out of your day to come chat with me, chat with my chat. And I like having that information, having someone who really does cover this stuff. It really means a lot. Do you make content, inform people yourself at all, or are you just mainly sticking to your job profession?
Oh, dude, I need to. And there's a friend of mine who's watching right now who's like biting her thumb at me about this. Like I have intended to, but 10 o'clock at night, a couple of Tuesdays ago, I might have, theoretically put together a video, but what did I do instead? I got involved with a case and made a difference in someone's life.
Mr. Workaholic, yeah.
Well, there's relatively few really good lawyers out there who make content. I'll say Mike Raffi he's a real lawyer, that dude actually knows what the hell he's doing. Hogue Law, yeah, you can tell because he's boring. Like
he's doing it exactly as it should. He's not getting the creative comment when he goes to court.
Bingo. So there are some other lawyers out there who have covered cases that I've been involved in, who have very popular channels, who are not really lawyers.
It sounds like it'd make a banger video, Mario.
I'm not going to make. I have thought like I should do a reaction video to people who talk about free speech and just clarify whether that's correct or not, and do a reaction video to a bunch of one or a number of streamers, and it's in my head to do this, but then I just end up
doing the job that you're really good at. Consistently, yeah. Okay, well, fair. Is there? Could I direct them if you have like a link to your YouTube or anything like that? If you don't plan to, I'm not going to pressure you into that. I just want to make sure you
send them to my YouTube. Send them to speechdefense.com if you want to post that. Speechdefense.com or freespeechdefenselawyer.com is my website. It's not complete. It has some materials on there.
Yeah.
I don't even love it, but it's got some things on there. So but that's where you can find, if you hear someone with a free speech issue, even if I can't help them where they're at, I will probably know someone in their state.
Well, take care. Enjoy your evening. Thank you again so much. We'll see ya. Adios. Something like that. I'm bilingual.